Joint Lunar Polar Exploration Mission. Joint Lunar Polar Exploration Mission. We have already discussed about Chandrayaan 1 and Chandrayaan 2, right? So this is a different mission. This is Joint Lunar Polar Exploration Mission. This is a joint mission by ISRO and JAXA, Japanese Space Agency. ISRO and JAXA, JAXA, it is Japanese Space Agency. Right, so ISRO and JAXA together are taking up this joint lunar polar exploration mission. This is basically to put, the objective of this mission is to put a lander and a rover on the moon's surface. And on what part of the moon's surface? On the south pole region of the moon's surface. Right, on the south pole region of the moon's surface. And this is a 6-month mission. And how is ISRO contributing? ISRO is developing the lander for this mission. Right, in Chandrayaan 2, we have discussed that we have tried Vikram lander, right? For soft landing, Vikram lander. In Chandrayaan 2, for this mission, ISRO is developing the lander. JAXA is developing the rover. Now compare this to Chandrayaan 2. What was the name of the lander in Chandrayaan 2? It was Vikram. What was the name of the rover in Chandrayaan 2? It was Pratham. It was Pratham, right? Keep revising these things, guys, otherwise we'll forget them. So ISRO is developing lander, JAXA is developing the rover. What for is this mission being taken up? This mission is being taken up to assess water distribution on the moon's surface. Water distribution on the moon's surface. Water was found by Chandrayaan 1 on the moon, right? Water was found by Chandrayaan 1 on the moon. With the help of NASA, Chandrayaan 1 discovered water on the surface of the moon. Chandrayaan 2 tried to map the water resources on the moon. But unfortunately, our lander could not perform its duty properly, right? Because of which Chandrayaan 2 was a partial success, not a complete success. So similarly, Joint Lunar Polar Exploration Mission is also about water distribution, assessing the water distribution in the moon, and also feasibility of resources exploration. Feasibility of resources exploration. When we were discussing Chandrayaan 2, we have discussed about some important resources that are available on the moon. Just go through them, right? And this is different from Chandrayaan 2 in one sense. Which region did Chandrayaan 2 try to explore? Chandrayaan 2 tried to explore the unexplored southern pole region of the moon, right? We have already discussed this. Unexplored southern region, pole region of the moon. Joint Lunar Polar Exploration Mission is also about southern pole region of the moon, but not the unexplored one. The sunlit region, SUNLIT, sunlit region. Sunlit region means that region or that part of the southern pole region which is exposed to sunlight. Right? Chandrayaan 2 tried to land on unexplored southern pole region. What was that unexplored? That also we have discussed. It's about the part of the moon which is not visible to the earth. The part of the moon which is not visible to the earth. The part of the moon which doesn't see the sunlight. Right? The part of the moon which doesn't see the sunlight. So that is called unexplored region. But this Joint Lunar Polar Exploration Mission is not about unexplored southern pole. This is about sunlit region. Constantly sunlit. Sunlit means sun's exposure is there continuously. Right? So this is one difference. So this is about Joint Lunar Polar Exploration Mission taken up by ISRO and JAXA. Right? ISRO is developing the lander, JAXA is developing the rover. Is to explore southern pole region of the moon. For what? For water distribution and for feasibility of resources exploration. Which region? Sunlit region of the southern pole. Whereas Chandrayaan 2 was about unexplored southern pole of the region. This is about briefly about Joint Lunar Polar Exploration Mission. Now another topic, an important topic which we are going to take up is reservations. right? Reservations. So this topic was also in news because we have seen various Supreme Court judgments regarding reservations, right? The latest Supreme Court judgment, what did it say? It said that reservation is not a fundamental right, but it is an enabling provision. It is an enabling provision. Depending on the circumstances, the state has discretion whether to apply reservations or not. So this was the recent judgment. Similarly, there was also another judgment. So we'll start with this judgment and we'll try to cover all the constitutional provisions related to judgment, which are important for prelims. We'll try to analyze this reservations topic with respect to prelims. Firstly, we'll start with the recent Supreme Court judgment regarding 100% reservation for scheduled tribes in the scheduled areas. So if you remember, 2 or 2.5 months back, there was a Supreme Court judgment. So what happened was our Andhra Pradesh state government, in the year 2000, it has passed a government order. It has passed a government order which said that in the schedule areas, 5th schedule areas, I hope this is, everyone knows about this, right? So in 5th schedule areas, this government order said that in 5th schedule areas, 100% reservation for scheduled tribes. 100% reservation for the scheduled tribes, right? So such a government order was passed in the year 2000 by the AP state government. So recently a Supreme Court judgment has striken off this provision of AP government order, right? It said this provision of providing 100% reservation for the scheduled tribes in the scheduled areas is not permissible. This is what Supreme Court said in its words. What did it say? It said 100% reservation for STs in the scheduled areas is not permissible. And why did it say like that? It said it gave some strong supporting points also for this. What did Supreme Court say is such a provision which is giving 100% reservation for scheduled tribes in scheduled areas, it is discriminatory. It is discriminatory. This word was used by Supreme Court. Second thing what it said was it is impermissible. It is impermissible. And also it said such a government order violated Article 14. It violated Article 14. It's about right to equality. It also said this provision violated Article 15 also. Article 15 also. And also Supreme Court spoke about Article 16 also. So Article 14, 15, 16, these three were cited by Supreme Court when it was striking off this 100% reservation rule for the scheduled tribes, right? So this is about the judgment and the government order, right? We need to have a brief knowledge about them. Now, with respect to prelims, we have to know what are these 5th schedule areas, what are these 6th schedule areas, what are different constitutional provisions about reservations, what are the different articles related to reservations, and what are the different important Supreme Court judgments about reservations, right? Because name of the judgment, name of all the judgments which are related to reservations, and constitutional amendments that were made related to reservations, including the recent 103rd Constitutional Amendment Act for economically weaker section 10% reservations. All this we will try to cover. First, we will start with 5th schedule and 6th schedule areas. This 5th schedule, 6th schedule areas not only in news because of the Supreme Court judgment, but also 6th schedule areas was in the news because of Citizenship Amendment Bill also. In Citizenship Amendment Bill, this 6th schedule areas are given exemption. We have already discussed Citizenship Amendment Act, just revise it. And also the 6th schedule areas, they were in the news because a constitutional amendment is also being planned for the 6th schedule areas, right? A constitutional amendment bill where directly funds from Consolidated Fund of India will be given to the 6th schedule areas, right? Such a constitutional amendment is also being planned by Government of India. Just go through that constitutional amendment also, right? It is, if I am not wrong, 126th Constitutional Amendment Bill. Just go through it, guys. So that Constitutional Amendment Bill says giving more financial autonomy to 6 schedule areas. So this is the reason why 5th schedule and 6th schedule were in news like anything. So we need to focus on them. Firstly, we'll start with 5th schedule areas. So basically, what are these 5th schedule and 6th schedule areas? What is done in these areas? It is about administration in tribal areas, right? How administration in tribal areas should be. So it is somewhat different from the normal areas. How is it different? We will be giving some special provisions to the tribal people in these areas, right? So that is why 5th schedule and 6th schedule areas came into picture. So 5th schedule and 6th schedule areas, they came under the Article 244. Article 244. This is the article which speaks about 5th schedule and 6th schedule areas, right? So under 5th schedule areas, some regions where basically tribal population is more, those areas are designated as schedule areas. Those areas are designated as schedule areas under the 5th schedule, right? So this is about administration in the tribal areas. Now 5th schedule areas are present in which states? 5th schedule areas are present in Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, MP, Maharashtra, Odisha and Rajasthan, right? In all these states, 5th schedule areas are present. AP because in the north coastal Andhra region, we have tribal dominated regions in Andhra, right? Telangana also we have tribal areas. Chhattisgarh, Odisha, Himachal Pradesh, Gujarat, Jharkhand, MP, Maharashtra and Rajasthan, right? So all these states we have 5th schedule areas. Broadly we have to know like which states have. Now how are these schedule areas designated? Who designates this? It is designated by President. It is designated by President of India, right? So President of India will notify the schedule areas, right? If an area is to be designated as schedule area in some state, it is President of India's order which is required. This is important because they can confuse us here with governor. They can say governor designates 5th schedule areas. No, President designates 5th schedule areas, right? That is one area. And President designates the 5th schedule areas after consultation with governor, right? So finally it is the President. However, consultation with governor will be there. So this point we have to be clear. And every year governor will be submitting a report to the President. Every year governor will be submitting a report to the President about the administration in the schedule areas, right? That is one point we have to know. And how is administration taken up in the schedule areas? Tribal Advisory Councils, TACs, Tribal Advisory Councils are set up in this 5th schedule areas. Tribal Advisory Councils are set up in this 5th schedule areas. For more details, you can also refer Lakshmikant Polity, guys. All these points are there in Lakshmikant Polity also, right? So Tribal Advisory Councils are set up. What are these Tribal Advisory Councils? They consist of 20 members. It is a 20-member body. This 20-member body, 3/4 representation should be from the tribals, right? 3/4 representation should be from the tribals in this 20-member body. What is this Tribal Advisory Council? This basically tries to make plans for the development of tribal regions, right? So this is about Tribal Advisory Council. And another important rule in the tribal areas is if Parliament or any state makes a law for a particular state or India, that law may not be applicable to schedule areas, right? So that will be decided by the governor. Assume Parliament has made a law for the entire India. Now, whether that law is applicable to schedule areas or not, it is the governor who will decide, right? And if needed, governor can modify that parliament law and then apply it to the schedule areas. So this point is important. If any law is made by parliament or the state legislature, it is the governor who will decide whether that law should be applied in the schedule areas or not, and if any modifications are required or not, right? So this point, so the AP government order which we have discussed just now, that is based on this point only. We know that there are laws for reservation, right, in India. So that law for reservation was modified by the governor using this provision. Using this provision, governor modified that particular law and told that 100% reservation for scheduled tribes in the schedule areas. However, that was stricken off by Supreme Court, right? So that's why this rule is important. So this is everything about 5th schedule areas, right? First thing, it came under Article 244. That is the first point. Second point, what all states we have the schedule areas. Third point, who designates the schedule areas? It is the president who designates the schedule areas after consultation with the governor, right? And governor submits an annual report to the president about the administration in the schedule areas. We have tribal advisory councils in the schedule areas, 20-member body in which 3/4 representation from the tribals, right? So this is an advisory body, and if any parliament law or state law is made, how it should be applicable to these schedule areas and whether it should be applicable or not, that will be decided by the governor, right? These points are important because they can confuse us between president and governor. They can say any law can only be modified or implemented in schedule areas by the president. That is wrong, right? It is the governor. So these are some points about 5th schedule areas. So we'll take up 6th schedule areas. So 6th schedule areas also are designated under Article 244 only, right? Under Article 244 only. So 5th schedule and 6th schedule, both under Article 244. Now the second point, 5th schedule states we have discussed. 6th schedule states are basically northeastern states. Assam, Meghalaya, Tripura and Mizoram. Assam, Meghalaya, Tripura and Mizoram. These are the 4 states in which 6th schedule areas are there under Article 244, right? So 5th schedule states we have discussed, 6th schedule states are AMTM, Assam, Meghalaya, Tripura, Mizoram, right? This is one difference between 5th schedule and 6th schedule. And this 6th schedule areas, they came under the recommendation of Bardoloi Committee. They came under the recommendation of Bardoloi Committee, Bardoloi Committee, Bardoloi Committee, Bardoloi Committee. Committees are important, guys. We have already discussed various committees, right? Shekatkar Committee for Border Infrastructure, Naresh Chandra Committee for Chief of Defence Staff, right? Bibek Debroy Committee for Railway Reforms, right? Shanta Kumar Committee for Food Corporation of India. This way, number of committees we have discussed. Just revise those committees, right? Names are important for us. So Bardoloi Committee recommended for 6th schedule areas, right? So how are these 6th schedule areas different from 5th schedule areas? In 6th schedule areas, we gave more autonomy to these areas compared to 5th schedule areas. Compared to 5th schedule areas, 6th schedule areas have more autonomy. How do they have more autonomy? We will be discussing this, but this is one difference which we have to know, right? 6th schedule areas have more autonomy. And who designates the 6th schedule areas? It is the governor who designates the 6th schedule areas, right? It is the governor who designates the 6th schedule areas. And it is the governor who organizes and reorganizes the boundaries of the 6th schedule areas. It is the governor who organizes and reorganizes the territories of the 6th schedule areas, right? So that is also important. And we have a tribal advisory council in 5th schedule area, right? We have a tribal advisory council in 5th schedule area. we have autonomous district councils in 6th schedule areas, right? We have autonomous district councils in 6th schedule areas. This is another difference between 5th and 6th schedule areas, right? Autonomous district council, as the name itself suggests, autonomous district councils have more autonomy and more powers compared to 5th schedule areas, right? This point also we have to know. And also regional councils are also set up in this 6th schedule areas under the autonomous district councils, right? So why are or how are the autonomous district councils more powerful than tribal advisory councils? Because some extra powers are given. Those extra powers are, first is autonomous district councils can make laws on specified matters. They can make laws and legislations on particular matters like land, forest, water, right? On land, forest, water, and many other subjects, directly autonomous district council that can make laws and legislations. But do we have any such provision in 5th schedule area? No. Only governor has the power. That too, to amend any particular parliament law and implement it in schedule areas, right? So autonomous district councils are given this power. They can make laws and legislations on subjects. Second thing, related to customs and traditions of the tribes. Related to customs and traditions of the tribes also, autonomous district councils have complete autonomy, right? So they can make their own rules, they can make their own customs and traditions, right? They also cannot be touched by governor or president, except on special situations. Except on special situations, customs and traditions completely under the control of autonomous district councils. This is the second power. However, one small thing here which we have to be careful is, autonomous district councils are given the power to make laws and legislations. However, governor is the final body who has to give assent to those laws and legislations. Governor is the body who has to give the assent, right? This point we have to know. And these autonomous district councils can even set up courts, village courts. They can even set up village courts. So that power was also given. That means they can set up their own courts. Apart from the judiciary system which we have, the district courts, high court and the Supreme Court, outside of this, the autonomous district council they themselves can make this village courts. That power is also there. And appeal to these village courts, is it there for high court or not? That will be decided by the governor, right? That will be decided by the governor, right? So that point we have to know. And even these autonomous district councils can even collect land revenue. They can even collect land revenue. They can even impose taxes on various subjects, and they can even construct public infrastructure like schools, right? Healthcare systems, etc. So these many powers were given. These many powers were given to autonomous district councils in 6th schedule areas, which were not given to 5th schedule area. 5th schedule area only we have tribal advisory council. They only give recommendations, right? It's an advisory council, not an executive body like autonomous district council, right? So this is completely about 5th schedule and 6th schedule areas, guys. And also go through the recent constitutional amendment bill that was in the news related to 6th schedule area, and also Citizenship Amendment Act. 6th schedule areas were given exemption, right? That rule also we have to be careful, right? So this is everything about 5th schedule and 6th schedule areas. So now we'll try to take up the articles and judgments related to reservations, right? The articles and judgments related to reservations. First one is Article 15(4). Article 15 brackets 4, right? Article 15 brackets 4. Now we know that Article 15 is about no discrimination or prohibiting the discrimination, right? That is Article 15. Article 15(4) is about reservation for SC and ST communities in educational institutions. Reservation for SC and ST communities in educational institutions. That is Article 15(4), right? Next, Article 16.4. Article 16.4. Article 16.4 is about reservation for SC and ST in public employment. Reservation for SC and ST in public employment. What is Article 16? Prohibition of discrimination in public employment, right? Equality of opportunity in public employment. That is Article 16. Article 16.4 is reservation for SC and ST communities in public employment. Right? This is Article 16.4. Next article is Article 46. Article 46. So this is basically a DPSP. Article 46 is a DPSP, Directive Principles of State Policy. Now, how is Article 46 related to reservation? It's related to reservation because this article says or talks about protecting the educational and economic interests of weaker communities. Right? Article 46 talks about protecting the educational and economic interests of weaker sections. Weaker sections. This Article 46 is the basis for reservations. Under this Article 46 only, either it is for SC or for ST or for OBC or for EWS, for all these communities, reservations are being given based on the philosophy of Article 46. Right? This is also known as Gandhian DPSP. This is also known as Gandhian DPSP. So this article says protecting the educational and economic interests of weaker communities. So that's why reservations were brought in Article 15 and 16, right? So this article we have to know. Next is Article 243D. 243D. This is about reservations for SC and ST in panchayats. Reservation for SC and ST in panchayats. Right? There also proportional to their population, reservation is given for SCs and STs. Right? To the members of panchayat. Chairperson of the panchayat reservations is the discretion of that particular state legislature. Right? This we have to know. In local bodies, we have reservations for women, we have reservation for SC, and we also have reservation for ST. For OBC, reservation is optional. For OBCs in local bodies, reservation will be decided by the state legislature. Right? These are some minute differences where they can confuse us. In local bodies, we have reservation for SCs, for STs and women. OBC, it is optional and state legislature will decide. SC, STs also, for members of panchayat, we have reservations. For the chairperson posts of panchayats, reservations, how much should be given, that will be decided by state legislature. This point also we have to know. Article 243T, T for tiger, Article 243T. This is about reservation for SC, ST in municipalities. Right? Reservation for SC, ST in municipalities. Right? So local bodies, we have reservations. And Article 330, we have discussed this few days back. Article 330 is about reservation for SC and ST in Lok Sabha. Right? Reservation for SC and ST in Lok Sabha. In Rajya Sabha, do we have reservation? No. We don't have reservation for SC, ST in Rajya Sabha. Right? Only 12 members will be nominated in Rajya Sabha by president. Right? Only that is there. Reservations are not there. Article 332. Article 332 also we have discussed. That is about reservations for SC, STs in state legislative assemblies. Reservation for SC, STs in state legislative assemblies. Right? That is Article 332. Next is Article 335. Article 335. What does Article 335 say? Article 335 says reservation provisions should not affect administrative efficiency. Right? Reservation provisions should not impact administrative efficiency. So Article 335 talks about administrative efficiency. Right? This Article 335 administrative efficiency is in some sense basis for 50% ceiling on the reservations. Right? This administrative efficiency. This is in some sense basis for 50% ceiling for the reservations, right? So this article we have to know. And EWS reservations, this was the latest one. Reservations, 10% reservations for economically weaker sections, right? 10% reservation. This was brought by 103rd Constitutional Amendment Act. 103rd Constitutional Amendment Act in the year 2018. Now, this reservations for economically weaker sections was brought by amending Article 15 and 16. By amending Article 15 and 16, right? New provisions were added in Article 15 and 16. What are those new provisions? They say economic backwardness can also be a criteria for giving reservations, right? So this will be taken up in a coming judgment called Indira Sani, right? In that judgment, the particular judgment clearly says social backwardness should be the basis. And economic backwardness cannot be the only reason for giving reservations. But 103rd Constitutional Amendment Act has put provisions in Article 15 and 16 saying that economic backwardness alone can also be a criteria for giving reservations, right? So 103rd Constitutional Amendment Act basically amended Article 15 and Article 16. This point we have to know. And another important point is this economically weaker section reservations are only being implemented by central government for central government jobs, right? This is optional for state government jobs. This is optional and this is up to the state government whether they will implement or not. This point is also important, right? If there is a statement saying 103rd Constitutional Amendment Act is providing reservation for economically weaker section in public employment of center and states, then that is wrong. State employment is in the control of state. It is up to the states whether they want to implement it or not. And not all the states have implemented this EWS, right? That also we have to know. Central government jobs only this is applicable. That is one point. And reservations are given to these communities based on proportion of their population, right? We have some formulas. For SC it is 15%, ST it is 7.5%, OBC is 27%, right? OBC is Mandal Commission, just go through that also, right? EWS it is 10%. EWS it is 10%, right? And then what about the reservations for PWD communities? That reservation is called horizontal reservation. That reservation is called horizontal reservation. Now the reservations which we spoke about for SC, ST, OBC and EWS, these are vertical reservation. That means 100 seats are there, 15 will be given to SC, 7.5 for ST, right? In this way it will be distributed. PWD is horizontal reservation. That means out of the seats reserved for SC, some seats for PWD. In the general category also, some seats for PWD. In the ST category also, some seats for PWD. This is called horizontal reservation. Horizontal reservation. In the last month, there was a Supreme Court judgment also about PWD reservations. Right? What did it say? It said that PWD reservations also should be somewhat same to SC/ST reservations because they are also facing social discrimination and they are also socially backward. So in this context, PWD reservations are also important for us. Right? So these are all the articles related to reservations. Now we'll come to all the important judgments about the reservations. Right? All the judgments. So first we have to go to 1951. In the year 1951 itself, reservations was an issue. Right? At that time we had this judgment called State of Madras versus Champakam Dorai Ranjan case. State of Madras versus Champakam Dorai Ranjan case. The same case can be seen as FR versus DPSP also, and the same case can be seen through the issue of reservation also. So State of Madras versus Champakam Dorai Ranjan case. This was the first case related to reservation. What did Supreme Court say in this reservation? It struck down the government order of caste-based reservations. Right? Article 46 we have discussed, the DPSP. Using that DPSP, the government at that time brought the reservations. that was challenged by this person called Champakam Dorai Ranjan in the Supreme Court. So what Supreme Court said, Supreme Court gave more importance to fundamental rights in that judgment and cancelled the government order of caste-based reservations, right? So that is the result of this judgment. And because Supreme Court has cancelled the government order of caste-based reservation, first constitutional amendment was brought. First constitutional amendment was brought. Why was this first constitutional amendment was brought? This was brought to amend Article 15 and to give reservations. So in that way we got Article 15(4). So first constitutional amendment act is related to reservations. Champakam Dorai Ranjan case is related to reservations. In Champakam Dorai Ranjan case, what did the Supreme Court say? It has stricken down the government order of caste-based reservation, right? The name of the judgment, what is the result of the judgment, and what is the outcome. These we have to know, and any important terms mentioned, right? This is first case. Second case is Indira Sahni versus Union of India. This happened in 1992 after Mandal Commission was appointed by the government of India for recommending reservation to OBC, right? I suppose everyone knows this, right? Mandal Commission was set up for recommending reservations to OBCs, right? And government of India gave a government order about reservations. Then that was taken up in Indira Sahni versus Union of India case in 1992. Some important outcomes of this judgment are, in Indira Sahni case, the Supreme Court upheld the government's decision to provide 27% reservation, right? So it did not strike down like in the Champakam Dorai Ranjan. In Champakam Dorai Ranjan, it has striken down caste-based reservation. But in Indira Sahni case, Supreme Court, it upheld the decision of government to provide 27% reservation. This is the first outcome. However, the Supreme Court brought in concept called creamy layer principle, right? Creamy layer principle. So this creamy layer concept evolved in this Indira Sahni versus Union of India case, right? What is that creamy layer? Just go and find it out, guys, if anyone doesn't know it, right? And third outcome is 50% ceiling on the reservations. 50% ceiling on the reservation. That means reservations given to all the communities should not exceed 50%. Assume there are 100 government posts. All the reserved seats should not exceed 50, right? Should not be more than 50. That is the 50% ceiling. That was also brought by Indira Sahni case. Indira Sahni case. And another important outcome is economic backwardness cannot be the only criteria, right? Social backwardness should be one of the criteria for giving the reservations. This was also told very clearly in Indira Sahni versus Union of India case, right? What was told? Economic backwardness cannot be the sole criteria. Social backwardness should be one of the criteria. So this is important. So this was also told in Indira Sahni versus Union of India, right? And also reservation for initial appointments and reservation for promotions. That issue also started after the Indira Sahni judgment only. So in this judgment, another important outcome was this judgment upheld reservations for initial appointments. But this judgment did not uphold reservation for promotions, right? It did not agree for reservation for promotions, right? There are two levels of promotions. One is for getting into a government job, reservation will be there. After getting into the government job, for promotions also reservation will be there as of now in India. So this Indira Sahni judgment in 1992, it said that reservations only for initial appointment and not for promotion. So these are the key outcomes in Indira Sahni versus Union of India, right? 27% reservation for OBCs was upheld, 50% ceiling was brought, creamy layer concept was brought, social backwardness should be the criteria, economic backwardness cannot be the only criteria, that was also brought, and reservations only for initial appointment, not for promotion. All these were said in Indira Sahni. These are the outcomes. And next comes the Nagaraj versus Union of India case. Nagaraj, M. Nagaraj versus Union of India case in 2006. What was said in this judgment? So this judgment is about reservations in promotions, right? So this judgment is about reservations in promotions. This judgment is not about reservations in initial appointment, right? Here we have to be careful. This judgment was about reservation in promotions. So here, what did Nagaraj versus Union of India, what did the Supreme Court say in this? Supreme Court said that it has accepted reservation in promotions, right? Indira Sahni, what did it say in that judgment, Supreme Court? It said that no reservations in promotions. But Nagaraj versus Union of India, the same Supreme Court, it said reservations in promotions are acceptable. However, 3 criteria were kept by the Supreme Court. 3 criteria. Only if those 3 criteria are satisfied, only if government proves those 3 criteria, only then reservation in promotions can be given. Those 3 criteria are: one is backwardness, second one is inadequate representation, and third one is administrative efficiency. Only if these 3 criteria, if the government can prove that a particular community is backward and a particular community is inadequately represented, and only if a particular community reservation is not affecting administration efficiency, only if these 3 are satisfied, only then reservation in promotions can be given for that community, right? So this is what Nagaraj versus Union of India judgment outcome, right? So these 3 criteria, it has upheld reservation in promotion, however on 3 criteria, right? And Nagaraj versus Union of India also told to extend creamy layer to SC and STs also. This is the second provision, to extend creamy layer to SCs and STs. So these are the 2 outcomes of Nagaraj versus Union of India. And next comes Jarnail Singh versus Lakshmi Narayan Gupta. Jarnail Singh versus Lakshmi Narayan Gupta, 2018 case this is, right? So in number of possible ways questions can be asked. Directly a question can be Jarnail Singh versus Lakshmi Narayan Gupta case related to, or match the following can be there, where on one side they'll give Indira Sahni, Nagaraj and Jarnail Singh, on the other hand 3 outcomes, right? In any way they can ask us, right? So that's why we need to be careful. So Jarnail Singh versus Lakshmi Narayan Gupta, this case said that this case also agreed for reservation in promotion. However, it said 3 criteria are not required, 2 criteria are enough, right? So government need not prove the backwardness of SC and ST, right? The Supreme Court said that government need not prove the backwardness. We already know that SC and ST are socially backward. So only 2 criteria. Supreme Court in Jarnail Singh said no need of proving backwardness. Prove administrative efficiency and inadequate representation. That is enough, right? That was one outcome. And second outcome is, again this judgment also, Supreme Court asked the government to think about extending creamy layer to SCs and STs, right? Extending the creamy layer to SCs and STs. This is about Jarnail Singh versus Lakshmi Narayan Gupta, 2018 case. And another judgment in 2018 was related to Karnataka Reservations Act. That was about BK Pavitra versus Union of India. BK Pavitra versus Union of India. So in 2018, Karnataka brought an act related to reservations and consequential seniority. Right, related to consequential seniority, Karnataka has brought a legislation. That legislation was also challenged in the Supreme Court in BK Pavitra versus Union of India. In that judgment, Supreme Court upheld the legislation of Karnataka, right? The legislation of Karnataka state government. What is consequential seniority? What is carry forward rule? Right? These 2 terms are also related to reservation, right? Mostly we will be getting confused. What is carry forward rule? what is consequential seniority, right? We'll be taking them up. So this is one judgment which upheld Karnataka's legislation about consequential seniority. And the recent Supreme Court judgment, we all know, that is that reservation is not a fundamental right but an enabling provision, right? It's an enabling provision. So these are all the judgments, guys. These are all the different judgments. And 3 constitutional amendments are very important when we speak of reservations. 3 constitutional amendments. One is first constitutional amendment, which we already spoke about. Another one is 103rd constitutional amendment, which we already dealt with. Other one is the recent constitutional amendment, which was extending 10 years of political reservation. That topic also we have discussed, right? Apart from these, 77th, 81st and 85th. These 3 constitutional amendments are important, right? 77th, 81st and 85th. 77th constitutional amendment is about reservation in provisions. When the Indira Sahni case, in that when the Supreme Court said that you cannot give promotion, reservation in promotions, then the government brought this 77th Constitutional Amendment Act in 1995 after the Indira Sahni judgment and introduced reservation in promotions, right? And a new article called Article 16(4)(a). Article 16(4)(a) was introduced. So 77th Constitutional Amendment, Article 16(4)(a) was introduced, which is related to reservation in promotions, right? This is one thing. Second is 81st Constitutional Amendment Act. 81st Constitutional Amendment Act. This brought Article 16(4)(b). This brought Article 16(4)(b). This is about carry forward rule. Carry forward rule. What is carry forward rule? For this, we'll try to understand this with an example. Assume this year 100 government posts are created, out of which 15 are for SC. Assume 5 of the SC seats are vacant this year, right? So next year also 15 seats are given for SC. Now should we add the previous 5-year posts or not? Right? If we add the previous 5-year posts also, number will be more than 50. Total number will be more than 50, right? Obviously it will be more than 50 because including OBCs we have 49.5%. That means if 100 seats are there, 50 seats reserved. If we include the last year's vacant seats also, it will be 55. So it is breaching 50% limit. But with this 81st Constitutional Amendment Act, what the government said is, if any posts are vacant, if any reserved posts are vacant in this year, they can be used for the next year. They can be used for the next year. This is called carry forward, right? This is called carry forward. This year's vacant posts can be used for the next year. And this is not breaching 50% limit, right? This is carry forward. If anyone could not understand, please go through the internet. With this basic knowledge which I told, it will be easy for you. Third Constitutional Amendment Act is 85th Constitutional Amendment Act. Third one is 85th Constitutional Amendment Act. This brought Article 16(4)(a) amendment. Article 16(4)(a) was brought by 77th Constitutional Amendment Act, reservation in promotion. Now 85th Constitutional Amendment Act amended this Article 16(4)(a). This is related to consequential seniority. This is related to consequential seniority. What is consequential seniority? This also we have to understand with an example. We can easily understand. Assume there are different levels. Obviously, there will be different levels in public employment, right? So assume a general category employee and a reserved employee in level 1. That is the ground level. Now a general category employee has 5 years of experience, okay? And the reserved guy has only 1 year of experience. So reserved guy has only 1 year of experience. General category has 5 years of experience. But when it comes to promotions, as we have reservation in promotions, the reserved guy got the promotion. Reserved guy got the promotion. but the general guy could not get the promotion. And after 1 year, general guy also got the promotion to level 2. Now if we see, now at the level 2, we have a reserved guy who has 1 year of experience, and we have a general guy who has 6 years of experience. Now who should be more preferable for promotion, right? Here, though the general category employee has 6 years of experience in level 2, the reserved guy will be considered more senior, because who came first to level 2? The reserved candidate came first to the level 2. So he will be considered as senior to this general category employee, right? This is consequential seniority. No matter how many years of experience you have, depending on in which level you are there, right? In that particular level 2, who has more years of experience? It is a reserved guy. So that's why this is called consequential seniority. So this is about consequential seniority. So this is everything about reservations, guys. The entire information I could get. So mostly if any question comes, it can come through this. If any extra dimensions are there, you please add them. So recently the Supreme Court judgment about 100% reservation for STs in the schedule areas. This was brought by AP state government. Supreme Court said it is not permissible because it is discriminatory, it is impermissible, and it is violative of Article 14, Article 15 and Article 16, right? So in this context, we tried to study 5th schedule and 6th schedule. 5th schedule and 6th schedule under which constitution? Article 244. 5th schedule which states AP, Telangana, Chhattisgarh, Odisha, Madhya Pradesh, Maharashtra, Rajasthan, Himachal Pradesh and Jharkhand. These are all the states. Who designates schedule areas? President designates schedule areas. Governor administers on the name of president, and he has to submit a report every year to the president. We have tribal advisory councils in 5th schedule areas. They give plans related to tribal development. Tribal advisory council, 20-member body, 3/4 should be STs, right? If any law made by parliament or state assembly, if you want to apply it to 5th schedule area, then governor has to decide whether to apply that law or not, and whether to modify that law or not, right? So this is everything about 5th schedule area. 6th schedule areas are, these also come under Article 244. These are in 4 states: Assam, Meghalaya, Tripura, Mizoram, right? So in this we have autonomous district councils. This came under Bordoloi committee recommendations. What are these autonomous district councils? These are 30-member bodies, right? More autonomy is given. What are those extra powers we have discussed? They can make laws on land, forest, water, etc. Customs and traditions also completely under the control of autonomous district councils. However, the laws made by this council require the assent of governor and not the president. They can also set up their own village courts and councils, right? Whether to appeal to high court or not, that will be decided by governor. Tribal or autonomous district councils can also collect land revenue. They can also impose taxes, and they can build some public infra. Citizenship Amendment Act also related to 6th schedule area, right? And also a constitutional amendment is being thought of to improve financial autonomy for this 6th schedule areas. Just go through them. Now coming to the articles. Article 15(4). What is it about? Reservation in educational institutions for SC/STs. Article 16(4) is about reservation in public employment. Article 46 is about DPSP, protecting the educational and economic interests of vulnerable sections, right? This is a Gandhian DPSP also. Article 243D is about reservation for SC/ST in panchayats. Article 243T, T for tiger, is about reservation in municipalities. Article 330 is about reservation in Lok Sabha. 332, reservation in state legislative assemblies. 335, reservations, administration efficiency. 103rd Constitutional Amendment Act, EWS reservations, 10% EWS reservations, central government posts, not to state government posts. Article 1516 amended. Economic backwardness also made a criteria. This is one area focus, guys. This area is important. And PWD horizontal reservations and the recent Supreme Court judgment also we have discussed. Now coming to the judgments, first one is 1951 Champakam Dorai Ranjan case. Champakam Dorai Ranjan, State of Madras versus Champakam Dorai Ranjan. Here caste based reservation the Supreme Court did not support, and then first constitutional amendment was brought. This is about that case. Second is Indira Sahni versus Union of India case. This case spoke about supporting 27% reservation for OBCs, creamy layer concept, 50% ceiling, reservations in initial appointment, not for promotion, and economic backwardness cannot be the sole criteria. Social backwardness should be one of the criteria. This is Indira Sahni judgment. Next comes Nagaraj judgment. This is about reservation in promotions, right? It upheld reservation in promotions. 3 criteria were kept: administrative efficiency, backwardness, and inadequate representation. Also asked the government to think about creamy layer for SC/ST communities also. Next comes the Charnail Singh versus Lakshmi Narayan Gupta judgment 2018. In this it said no need to prove the backwardness of SC and STs, right? They are socially backward. So only 2 criteria: administrative efficiency and inadequate representation. This judgment also asked the government to have a relook about creamy layer to SCs and STs, right? And next judgment is about BK Pavitra versus Union of India. Karnataka has made a legislation about consequential seniority, right? About that, the Supreme Court has upheld the consequential seniority. And the recent Supreme Court judgment where it said reservation is not a fundamental right, however, it is an enabling provision. 77th Constitutional Amendment Act, Article 16(4)(a), reservation in promotions. 81st Constitutional Amendment Act, Article 16(4)(b), carry forward rule. 85th Constitutional Amendment Act, Article 16(4)(a), consequential seniority, right? This is the entire information, all possible dimensions information about reservation, guys.